I'd like to now introduce Louise Johnson. She's part of VARTA, and this is regarding legal issues in surrogacy for Australians. Louise is the CEO for VARTA since 2005, holds degrees in microbiology, education management, and masters in regulatory studies. Thank you.
Thanks very much. And just before we start, I want to say thank you to the two men who shared their personal stories. It was fantastic, great session. We're going to now move on to legal issues in surrogacy in Australia and look at some aspects associated with things that you need to think of before treatment, during the pregnancy, and not only post-conception but after the birth as well. And we've got three lawyers who are going to help us work through this. And I'm just going to introduce them. The first one is Ben Sayer. Ben is with TJ Mulvaney Solicitors. Is that correct, Ben, or have you changed jobs?
I've actually moved on to my own firm now. It's uniquely called Sayer Jones with a mate of mine, Will Jones. So, yeah. It's equal parts excitement and white hot panic at this stage.
Okay, thanks Ben. Ben was admitted to practice in the High Court and the Supreme Court of Victoria. He's a member of the Law Institute of Victoria and has advocated extensively in family law and has represented clients in relation to domestic altruistic surrogacy for over a decade. He's advised extensively on domestic and international adoption surrogacy and takes a personal interest in this unique and specialised area of law. Ben's also helped VARTA with some of our education events. I'd also like to introduce Monica Blizzard. Monica is with Logie Smith Lanyon Lawyers, and Monica, you're still there?
I am still there.
Good. Monica is an accredited specialist in family law based in Melbourne with more than 20 years experience as well as broader experience in family law. She has a passion for surrogacy and adoption and making sure that surrogates, parents and children alike are protected throughout the process. I'd also like to introduce Linda Wright with DGB Lawyers. Linda was admitted as a solicitor in 1981. She joined DGB Lawyers in 1986 and became a partner in 1991. Linda has developed a specialist practice in domestic surrogacy and has given evidence to parliamentary inquiries in Queensland and New South Wales in this area. She has many years' experience helping clients resolve differences in an atmosphere of mutual respect. And what I'd like to do is to start off by asking each of you, if you're thinking about entering into a surrogacy arrangement in Victoria, what should intended parents and surrogates consider before they get involved with any arrangement?
Well, perhaps I'll start at the beginning. Obviously, one of the biggest challenges is finding a surrogate. Most of my arrangements that I've been involved in have been interfamily, so mother-daughter or more often siblings. And that's often an excellent basis from which to start an arrangement if you're lucky enough to have someone in your family who's prepared to do it for you. I think the main reason for that is because there's already such a strong trust bond, and that's a really important part of a surrogacy arrangement. But if you can't find someone who's close to home and you're looking at other alternatives, I think it's really important to know who it is you're making your arrangement with. I was having a chat with a fellow who'd undertaken a couple of surrogacy arrangements with essentially a friend, and one of the things that they'd done before they'd even really seriously looked into the legalities of going into their arrangement was sit down over dinner, and he said a fair few bowls of wine, and essentially have a Jeffrey Robertson style hypothetical and say, well, what are we going to do in this situation? What are we going to do if these problems arise? And I'd certainly encourage that. I know it's part of the counselling processes that you go through, but those early discussions can really help you vet potential options for surrogacy arrangements, but also make sure that you're starting on a footing on the same page. So from a starting point, getting an actual surrogate who perhaps isn't close to home, it's really important to cover some of those issues off early.
It's also important to know that certainly in Victoria you can't advertise for a surrogate, and that's also part of the reason that family and friends end up being often the surrogate in the scenarios that we deal with. But it's been really interesting for me as a lawyer listening to Lisa Slaughter, who spoke a couple of sessions before, and how California law has really evolved with surrogacy. Unfortunately, our laws haven't, and my firm view, and I think our collective view, would be they need to. So whilst you can enter into a written agreement about a surrogacy arrangement, you've also got to understand that they're not actually legally binding. The court could take them into account in determining parenting arrangements and so forth, but the document itself it's evidence of the agreement, and that's really all it can be. But it's still incredibly important, and the lawyer in me will always say, document as much as you can. Have the conversations you need to have, and document everything you can. I think it's vital to do that, and make sure everyone gets the counselling we've talked about. It's been very interesting hearing from the surrogates as well today, and how important that counselling process has been, both before and after and so forth. So working that into the arrangements in terms of the compensation element and the long-term aspects in terms of the counselling and all of those sorts of things.
Linda, you operate in different jurisdictions in New South Wales and Queensland. What's your perspective?
Yeah, a little bit different. I agree completely with those comments that, particularly in domestic altruistic surrogacy that I've had dealings with, it is generally family, sister-in-law, sisters, siblings, mothers in some cases, sometimes cousins, that offer to be the surrogate. But I've certainly had clients who have used friends of friends, and just as Ben gave that example, I understand what they did was they met up beforehand, they had a weekend away together, the intended parents met the children of the potential surrogate, and they just got a feel for each other before they committed. I'm a little bit different to Monica in terms of what I put into my agreements. It's clear in New South Wales the agreement's not binding. The only part of the agreement that's binding is the obligation on the intended parents to meet the costs of the surrogate, and therefore I try to keep my agreements as simple as possible. What I put into them, I make sure that I cover all of the preconditions that the Supreme Court says have to be met in order to transfer the parentage after the birth. So all of those go in, and we certainly have the conversation around other areas, but I generally leave that to the counsellor, and that's a very, very intensive process that has to occur before the agreement can be entered into. So a lot of that discussion about what's going to happen during the pregnancy, I don't put into the agreement, because I've taken the view that if there's going to be problems, that will often be picked up in the counselling process, and a lot of my clients, they've even completed their counselling before they get to me.
Ben or Monica, do you want to make comment about any things to think about during the pregnancy, or comment on what Linda has just said?
I would just say the things that I was really referring to are the big issues that even, I must say, is that I've faced infertility myself. I've gone through IVF, and I even think back to the issues I've had with my husband in terms of if we had genetic difficulties with my child, my husband and I couldn't even often get on the same page, and I can imagine how difficult it is to try and come to terms with someone that you may not know very well, or you haven't had an intimate relationship with. So just canvassing the main issues of what would happen if something goes wrong in the pregnancy, what happens after, what is the birth plan, how is that going to work, and those main issues I think are really, really important to have that conversation and have it thoroughly.
Yeah, Victoria hasn't had a requirement for written agreements as part of the surrogacy arrangement, so we don't have the same framework as some other states. I remember when the legislation was first introduced in Victoria, we had some focus groups with some of the registered ART providers back home, and there was a group of lawyers, and as lawyers tend to do, we sat down and tried to decide how many issues might arise in these types of arrangements and what might need to be addressed in an agreement if parties wanted to undertake one. And of course it was a cost-benefit analysis really, because if the agreement's unenforceable, the parties really want to spend so much money dealing with so many issues. I think I was one of the worst culprits, because I've been lucky enough to read a lot of the US and other countries' arrangements and documents, so I was sort of alive to some of the issues that might come up. And we sort of settled on the realisation that this probably wasn't a cost-effective thing to be done, and that we liaised quite heavily with the counsellors within the registered ART providers about the sorts of issues that they'd address in counselling. And I think we've been fortunate in that they then offer us feedback about the sorts of issues that they're finding come up in a number of arrangements, and that's quite helpful for us in conducting our discussions with clients, because we don't have to go through the process of drafting an agreement, and because they do come to us after they've had the counselling. Often you find yourself sitting across from people who are saying, yes, we know all this, we're fine, we're ready to go, please just write our letter and we can get cracking, because they're eager, they're excited, they're at that stage where things are about to start happening, so that's perfectly understandable. But I always encourage people just to make sure that they've cast their mind to those things, and it ties in with the advice that we have to give about what their legal entitlements and responsibilities are, where they stand in the eyes of the law, both on a state, territory or federal level. So it's a reiteration, and I always apologise to my clients for doing it to them, but I think it's an important part of the process.
Thanks. Let's talk post-conception. Then did you want to start off by telling us what happens in the parental transfer process in court and explain the role of the lawyer?
Sure. Again, New South Wales is probably a little bit different to the Victorian system, but effectively, once the baby's born, if you have met the preconditions, that is, if you've had pre-embryo transfer counselling, if you've had legal advice, if you've had a written agreement, then you are eligible to apply for what's called a transfer of parentage. So when the baby's born, the law in my view is clear. The intended parents are not the parents of the baby. The birth has to be registered, and the birth mother is the recognised mother of the child, and the partner of the birth mother, if she has one, is the recognised father of that child, provided he has given consent to the assisted reproductive transfer that has led to the pregnancy and the birth. So the birth certificate at first instance is birth mother, birth father. You have to transfer the parentage to the intended parents by way of an order of the Supreme Court of New South Wales, and that involves an application that can't be made earlier than 30 days after the birth and must be made within 6 months of the date of the birth. And again, there are some preconditions that you have to go through after the birth. There's got to be another round of counselling that involves all 4 parties, or 3 parties if there's no partner of the birth mother. That counsellor cannot be the same counsellor who counselled them pre-embryo transfer. Must be a registered and accredited counsellor. There are some requirements in the regulations that set out who is eligible to do it. Must prepare a written report that addresses a whole lot of criteria that are in the legislation. Then the birth mother and the birth father also have to have another lot of counselling, independent, and that is not to do with so much the surrogacy arrangement, but issues of grief and loss arising from the surrender of the child. That counsellor doesn't have to prepare a report, there just has to be evidence that the counselling's occurred and that it's an accredited and recognised counsellor in that particular area. So there's a little bit to do after the birth, and couples have got to get their skates on, really. So they get all of that underway, and then the application is prepared to the court, supported by affidavits, supported by the report of the independent counsellor. It's all submitted to the court within that 6-month period, and then there are a number of judges. It's the adoption division of the court that looks after this area. 2 or 3 different judges are allocated the work, and it's all done in chambers, by which I mean you don't actually go to court. The paperwork goes off to court, there's no lawyer going to court, it's all done within the court system. It takes, on average, if everything goes well and depending on how busy the court is, about 6 weeks, sometimes a little bit longer, and then the court will issue the order. When that order happens, the court also sends the order to the Registry of Births, Deaths and Marriages, and within about a further 4-week period after that, you can apply for the new birth certificate, which shows the intended parents now as the legal parents of that child.
Thanks. Ben and Monica, would you like to comment on differences in relation to Victoria and whether legislative changes passed recently in Victoria have affected intending parents in relation to these matters?
Sure. The process is almost the same in Victoria. There are a couple of notable differences though. The main thing I think is that there's no need for additional counselling post relinquishment in Victoria, and I think that's actually a real shame. The process itself is very similar. There's a 28-day period post-birth before we can file the application. I often find, and I say to clients, I understand immediately post-birth I'll be the last thing on your mind. You'll have a new baby at home. So I try and prep them beforehand to make sure they know what they need to get ready so that we can lodge our application when the time comes. Again, the court usually takes about 3 to 4 weeks to process documents, and then they list us for a hearing. We do have an actual hearing. It's not done in chambers, but it is done in camera. I actually really enjoy the hearings. It's quite an informal process, the way they're conducted in the Victorian County Court, which is the place that we normally make our applications. The judges will actually come down and meet the parties more often than not at the bar table. The commissioning or the intended parents are always there. The surrogate doesn't have to be, but can be, and friends and family are invited. So it's actually a really positive experience. I enjoy it because it's part of creating families instead of dealing with a breakdown, which is what we normally have to deal with in family law. I can't get yelled at by the judge. My clients are happy. It's actually really good. It can feel a little bit anticlimactic sometimes for clients because it's about 15 to 20 minutes and then you're all done. The official things that happen is the judge signs the order and the substitute parentage order register. At that point, you're officially stuck with one another. And then the same notification is sent on to the registry. And in about 2 weeks after that, the intended parents can apply for the birth certificate and it will show them as the parents of the child.
Monica, did you want to add to that?
No, that's generally it in a nutshell. They're very similar approaches, but I think the technicalities vary just slightly.
Let's, post-conception, let's talk about what issues can arise. And I think there's often a number of fears. For example, what if a surrogate refuses to sign parentage? What if intending parents refuse to pay bills? And there's differences between requirements across state borders in relation to these things and the way the law works. And what can a lawyer do to help? We might start again with you, Linda.
Okay, thank you. What if the surrogate and or the surrogate's partner don't give their consent to the transfer of the parentage? That's going to be a major problem for you in New South Wales. The consent, and I'm assuming we're talking about a situation where the care of the child has already been surrendered to the intended parents, so we've got the intended parents with the child in their care, but for one reason or another the surrogate refuses to cooperate in the transfer of parentage. The consent is a mandatory precondition and the court has no discretion on that. So if the consent's not forthcoming, you're not going to get a transfer of parentage order. My view would be in those circumstances what the intended parents are then limited to is an application to the family court or the federal circuit court for what are called parenting orders. So undoubtedly I think in those circumstances they'll get an order that says the child live with them, that they have parental responsibility for the child. That gives them the responsibilities of parenthood, but it doesn't give them the legal status of parents. So that's a potential problem, and it's one of the very reasons why I think New South Wales perhaps has got it very right in saying we've got to have this counselling pre-transfer, because those sort of potential problems should be picked up at that point. The only exception to the non-consent rule is that if for some reason the surrogate and or the partner can't be located, they've disappeared, then the court's got a discretion if the birth mother has died or has lost capacity to give legally informed consent, then that lack of consent can be overcome, but not otherwise.
Monica?
The situation is basically the same. If you don't have an agreement, obviously the agreements are unenforceable in any event. You're a significant person to the child. Certainly if the child's living with you and you're actually acting as their parent at the time, so you'd make an application to the family court or the federal circuit court for parenting orders in relation to that child, and the process would go forth from there. If you had a surrogacy agreement, then certainly that would form part of the evidence before the court. But thankfully there hasn't been a lot of those cases.
Ben, anything to add on that one?
Yeah, look, it's interesting. I mean, the provisions of our Act, which are essentially the same in terms of circumstances in which you can seek dispensation, they mirror the dispensation provisions in the Adoption Act, and I know obviously they're very different circumstances, but in terms of a dispensation of consent, some of the considerations are the same. The Adoption Act has a number of other grounds upon which dispensation can be sought, including things like a lack of involvement in the life of the child without reasonable excuse, or that the child is unlikely to accept a relationship with in this case, what would be the surrogate if we cross-apply. So it's interesting to me that there's not any other sort of avenue to dispense with consent. There's no consideration of the circumstances as to why a surrogate might feel that she's able to relinquish the child, which seems to be perhaps the most significant aspect of the surrogacy concluding, but not being able to consent to the order being made that would, give legal effect to the social reality for the child, and that comes back to the issue of best interests. In terms of if the commissioning or intended parents won't pay costs, Victoria again is a bit different to New South Wales, and it varies on a state and territory level. Our legislation is permissive, so it talks about the surrogate not receiving a material benefit or advantage as part of the surrogacy arrangement, but it says that costs may be reimbursed. So it's a permissive as opposed to a positive obligation. So there may be limited scope for what a surrogate can do if the intended parents refuse to meet reimbursements that might otherwise be permitted.
My last question is in relation to birth certificates. We've heard what happens in Victoria. Can you tell us about the situation with birth certificates here?
Well, I think I have mentioned that. I think we've heard about what happens in New South Wales. So the birth must be registered. It must be registered with the birth mother and her partner if she has one as the birth parents, and then it's changed when that transfer of parentage order is made.
Okay,
I might just add one more thing to that. If you're interested, there is a recent Supreme Court case which was arising out of an application for a transfer of parentage, and it's a case where, in fact, the intended father was put on the birth certificate as the father. The Supreme Court said that was clearly wrong. It can't happen. The Status of Children Act says clearly that person is regarded as the donor, and he's not to be regarded as the father of the child. There's an irrevocable presumption that he's not. Having said that, then the Registration of Birth, Deaths and Marriages Act says you can't give false information. So putting the donor intended father on the birth certificate's an absolute no-no, and it doesn't really achieve anything anyway, because you still have to make your application for transfer of parentage, otherwise the intended mother is going to be out in the cold.
I think we've got time for a couple of questions.
I have two comments and a question. First of all, comment to Linda in relation to the content of written agreements where it's required. Thank you for that. I agree with you that just include the bare minimum, because I see no point in drafting this Goliath of a document containing provisions which aren't enforceable anyway. In my view, those types of agreements which provide more than the bare minimum is an exercise in over-servicing. Second comment, in relation to the refusal of the surrogate in a altruistic arrangement to sign consent orders. Come to my next session, I'm going to be talking about the case of Green, Wilson and Bishop. Now, in relation to where the surrogates are not from New South Wales, Queensland or the ACT, what the intended parents could do is bring an application to Section 69BA of the Family Law Act for a declaration of parentage of the donor person, assuming the donor dad, leave for step-parent adoption, not in Victoria if they're a same-sex couple because it's not available as yet, but otherwise if it's opposite sex you can get leave for a step-parent adoption. You get your orders for parental responsibility to live with. That's stage one in the family court. Stage two, go to the county court, get your step-parent adoption. Question, Monica, in relation to written agreements, I'm assuming you're referring to Victoria, is that correct?
Yes.
Okay. Why would we have a written agreement in Victoria if it's not required?
It's not required. But I've done a number of agreements even for donors, and you often get clients coming to you when there are non-intimate relationships, wanting to set the boundaries for what might occur. Now, I'm not saying I do 20 or 30 or 50-page agreements, but I do think it's important that there's a conversation around the boundaries of what might occur when unexpected things do come up, and they do come up in these situations. We've heard about it all day today, about the things that can happen during a pregnancy or during the attempts to undertake IVF. So it's just important to canvass those issues.
I'd like to take another question. Thank you for those questions. We've got time for another question over here.
Just a quick one. Hopefully there are other people as confused about this as me, but we've heard from a lot of international agencies or people that are, help us facilitate international arrangements. What are the implications for us in Australia if you chose to do that? You talk about transfer of parentage in New South Wales, and that's presumably an Australian surrogacy arrangement. What are the implications with the recent changes to the law if you chose to go to, say, California, where everything is fine, but what happens when you come home? What's the implications of the law in that instance?
Are you speaking about that, Paul?
Looks like you were going to answer that question.
I think Paul's actually doing that in the next session, aren't you speaking?
Yeah, I think that's actually covered. The very next one.
So next session, and I'm sure Paul will
very long answer.
He'll have a lot of
answer
detail.
other questions as well.
Hi, just quickly. I've got a question, this is particularly Victoria, around compensation or what expenses you can actually provide for your surrogate, because I find this just such a murky territory and it scares the hell out of me. So I'd be interested in what the legal view of that is.
Sure.
Good question.
Mine might differ a little bit, but our Act, as I said before, it says that the surrogate can't receive a material benefit or advantage, and that's the only section in that part that actually attaches criminal sanction to it, okay? It then talks about a surrogate being able to be reimbursed for prescribed costs actually incurred. Prescribed costs are defined by the regulations, and they're pretty limited in Victoria, essentially as the costs associated with pregnancy that are medical, legal advice and travel expenses. It is an interesting question though, because if you read the explanatory memorandum to our Act, and it goes to that section and it talks about reimbursing, or the intent being to reimburse for costs actually incurred, and again they mention medical expenses, legal costs and travel, but then they also talk about lost wages. Now lost wages aren't within the definition of prescribed costs, so I think it raises the question, well, is the definition intended to be exhaustive or not? In terms of offering you a good night's sleep and me, there's been no test cases in terms of the litigation as to, or prosecution of people in those circumstances. I advise clients to take a sensible approach and to have regard to the definition as much as they can. But certainly there are some practices like obtaining life insurance for surrogates. That's not particularised in the definition of prescribed costs, but it's an accepted and sensible practice. So I think there's still a question there as to whether that is the definition and the only thing you can do, but certainly have regard to them.
And I think you're not the only one confused about that. I think it is a little bit murky and it certainly that varies from state to state too, so that makes it quite challenging.
Yeah. And the other states are much broader.
Monica, sorry?
I was going to say, can we hear that answer from a New South Wales perspective?
Just real quick, so it's now tea time, so we can continue going on as long as it needs to be, because I know that this is a very popular subject. But if you guys care to get tea, then you may also.
I'll just provide you with that answer quickly. It's a much broader range within the New South Wales legislation, and it's things like medical expenses, counselling expenses, lost wages, the insurance issue, that's covered. It could even extend to maternity clothes and things like that. So it's pretty well, as long as the surrogate is not obtaining a benefit from it, it's okay.
So focusing on compensation.
Yeah.
I think we probably need to wind up there. We're out of time. But I'd like to thank our panellists very much. It is a challenging area, and I think the questions and the answers illustrate that legal advice is just so important. So thank you all very much.